Well, thank you everyone for coming and joining me today on how to buy a business the right way, because I can tell you I've definitely seen it done the wrong way. All right. So if you don't know me, I'm attorney Danya Shakfeh. I've been an attorney for about 13 years now, and our practice is upstairs. And I focus on like business acquisitions and franchises, contracts, corporate startups. I'm a huge believer in helping business owners realize their personal and professional goals and dreams. And I used to do litigation, and I have found that a lot of people, the reason why they ended up in court is because they didn't have a good foundation in their business. And so I wanted to focus all my energies on educating business owners to actually have the good foundation for their businesses so that they can actually focus on profit and their dreams. So with that said, buying a business, I just want to take a quick poll. Is anyone here thinking about buying a business or recently purchased a business or no? Oh, you recently bought a business or?
Yes,
okay. Okay. Nice. Okay, great. So trying to see where we're at. And then, of course, at the end, there's going to be a Q&A. So I'd be happy to answer those questions too at the end. All right. So I already talked a little bit about myself. So I'll go to the next slide. So I wanted to start with, why do people buy businesses? And first of all, like, it might seem pretty obvious, like, oh, so first it's an easy entry into entrepreneurship, so instead of buying a business, or excuse me, so like instead of starting a business from the ground up, you can just go into buying it. The buyer already has a history, the financials, it's less risk, and there's existing customers. And then some people like to buy businesses because it can be a form of passive income depending on the type of business. So again, instead of like starting from the ground up, you like buy a business and then you can go do something else. And so those are really popular, like car washes, nail salons, like vending machine placements, are just like some of the few that come to my head as like passive income type of businesses that people buy. And then, of course, sometimes people want to buy businesses if they have an existing business and they want to grow their business and their market share through that way. And so there are two ways to do that. You can buy out your competitors, or you can buy a business that is complementary to your own business so that you could offer more services or products to your existing clients. And then the question is, why do people sell businesses? And as a buyer, you always want to ask the seller why they're selling, because that will give you some insight as to, one, if you should buy the business, or two, like what the price should be.
And
so
they never give you the right reason.
Well, that's why we'll talk about due diligence, right? So sometimes actually people are pretty upfront. Sometimes I can kind of tell that they're not being honest, but a lot of the times, again, like sometimes people don't enjoy being business owners, even in businesses where the business is successful. Because growing a business has its own headaches separate from buying from starting the business. Like, some people are really good at starting a business, but scaling is where they get stuck. And so even though they're making a lot of money, and they like having the freedom of being a business owner, it's not really coming with all the perks that they envisioned. So that's actually a good way to buy a business. So like if you're a buyer and you know how to scale the business, that's a good opportunity. And then sometimes a business is not profitable, and that's not all bad. If you're a buyer and you buy a business that's not profitable, but you could turn it around, and you could, negotiate a good price instead of having to start from scratch. So it's kind of like buying a home in foreclosure. Like, it's not completely worth this. You don't want to like buy the house, or you don't want to like build the house, so you can kind of negotiate a good price. And then, of course, some people just want to retire. I get so many people, like the seller's like, oh, I just want to move to Florida and I'm done, and I'm retiring. Yeah, so that's a good reason. And oftentimes those are really good opportunities too, because the business owners have been running their business the whole time and hopefully, successful. Sometimes they have a hard time parting with it, though, in that case, because they think it's more valuable than it really is. But anyway, so again, it's very important to ask that. And it's one of the first questions I ask. Like, once I'm hired as a lawyer, I ask the seller, like, why do you want to sell the business? All right, so how do you find a business that you want to buy? Well, there's a really good website called bizbuysell.com. It's kind of where people will list their businesses. It's kind of like, It's kind of like Redfin or Zillow, but for businesses. Two, you could just ask around if you know someone who wants to, sell their business. It's actually very common for an employee to buy the employer. Like sometimes the employer wants to not just be a business owner and the employee. Those are really good transactions because the employee has a pretty good sense of how the business is run. There's a really good relationship. So that's another way. And of course, you can use it's like a business broker. So people like from Transworld, they're kind of like real estate brokers, but for businesses. And they can help, find a buyer, and they do a pretty good job at like explaining the process and helping you evaluate the business so that you could sell it at a good price point. All right, so who do you need to vet a business? So I always like to say that when you want to buy a business, you need a team so that you make the right decision. Buying a business is people are often investing their whole life savings, and they have all these hopes and dreams. So you don't want to spend, like $80,000 or $100,000 or $1 million or $2 million or take out a loan or whatever it is to go and buy a business. You want to do it the right way, like I said. So I would say first, and not to be full, to toot my own horn too much, but I will, hire the attorney, and a good attorney is going to help you assemble that team for you. So in my case, like once I get hired, I ask my clients, do you have an accountant? Do you have a business coach? Do you have a business valuator? And other industry experts that may apply to that specific business. So because it's going to be, so like buying a business is going to be, it's going to be a legal decision, and then it's a financial decision, and it's also like a mindset, decision too. So that's why you need a good team, and that's how you vet those are the people that you need to help you vet the business.
So each one of those have, certain function to do. The attorney takes care of the legal matters. The accountant is the financial matters. And
yes. So I'm going to talk a little bit more about like the role and like the process of buying the business. But each person, of course, has their own role. So what's that process of buying a business? So, first people, they just want to get to know each other. Usually what I've seen is that the buyer and seller, or if there's a broker, then the broker and the buyer might get to know each other too, to kind of vet each other. So often the buyer, obviously the first question is this a profitable business? You don't want to buy something that is not profitable. And then there's a process, once the buyer and seller agree on the basic terms, then you're going to have something called the LOI, which is the letter of intent. And it's a mostly non-binding document to buy the business. And usually like if a buyer wants to show that they're serious, then they sign the LOI. And then there's an asset purchase agreement, or it could be a stock purchase agreement, but like the purchase agreement, which is that final, I don't know why I skipped due diligence, which is really important, but it's not on here, sorry. But like due diligence is when you actually investigate the business, and I'm going to talk more about that. And then at that point, like you do the purchase agreement if the parties want to move forward. And then of course there's the actual closing, which is it's very similar to a real estate closing. All right, so what's that process of getting warmed up and to get to know each other? So the buyer is usually looking out for, again, if it's profitable, if they trust the seller, because the seller is going to give representations about their business and talk about promises or like how their business was run. And so the buyer wants to make sure that they can trust the seller. And then the seller is they're looking for if the buyer one is serious, because they want to sell their business and they don't want to waste their time, especially if they have multiple offers. And then two, if the seller has employees, they often want to make sure that the new buyer is going to come and take care of those employees. And so if the buyer is kind, if they're trustworthy, if they're going to keep the business afloat after the seller leaves. And of course, show me the money is another example. So the sellers may show some financials, and then at that point, like a non-disclosure agreement is often signed, because of course the seller wants to protect their financials. They want the buyer to promise that they don't go and share that information everywhere. So some of the documents that the seller will often share is tax returns, but tax returns only tell a very small story of the financial health of the business. You want to look for profit and loss statements, like budget reports, cash flow reports, point of sales logs. And those will really give like the overall picture of the health of the business. Okay, and then the letter of intent. So again, it's people call it a non-binding document. I've seen many variations of them, but the parts that are non-binding would be, or excuse me. So it's basically like an informal offer, and the buyer isn't committing yet to buy the business, and there's like 1,000 ways to get out of it. Like if they choose to, or like if they change their mind, or if they find something in the due diligence that they don't like, or they don't get financing, or they just don't want to move on. And that's actually not a bad thing, because if the buyer commits too early to buying the business, I've seen that kind of go sour because the buyer's really not prepared, and then the seller gets upset, and you kind of don't want to do that. So it's good to like take your time. It's not a process to be rushed. But there are parts that are binding. So oftentimes, the seller will have the confidentiality clauses in there. One thing that I really advocate for my buyers is something called a no shop clause, where the seller promises not to sell the business to someone else while the buyer is doing their investigation. The buyer is going to start hiring a lawyer and an accountant and spending all this time. And the last thing that the buyer wants to do is have the seller be like, I know I just gave the tax returns, but I just sold it to someone else. Because the LOI is not binding, then there's really nothing stopping the seller from just, going and selling the business to someone else. And then the LOI will often spell out the purchase price. And then sometimes, though not always, there is a closing date and a due diligence timeline. And I always like to have a discussion with my buyers, in particular, what are the deal breakers? One mistake I see, especially when the buyer hires a lawyer too late and they try to either do it on their own, is that the buyer knows what the deal breakers are, but they don't voice it until the very end. And that just really sours the relationship. If a buyer or the seller already knows, I'm not going to sell this business if X happens, just have that discussion up front so that people are not wasting each other's time. Or alternatively, people can be prepared for those or those deal breakers. So for example, if you have a restaurant and the seller wants to keep some of the equipment for something else, maybe they want, to have it like a different restaurant, and the buyer knows up front that, okay, I'm going to have to buy my own refrigerator equipment. That's fine. That's something you can work with, but you don't want to find that out at the 11th hour right before closing. So that's what I advocate to. Due diligence. So due diligence is the research that the buyer gets to do to investigate the health of the business. And so I just put these in shapes so that it looks pretty, but the shapes don't actually mean anything. But for example, you want to have a more in-depth analysis of, the financial. So all the accounting that they have. A lot of small businesses don't have good good bookkeeping. And that's very common with small mom and pop shops. But when a seller does not have good, bookkeeping, then that's often a red flag as to what else is not being managed properly. I was recently working on a deal where the seller just sent an email with random expenses. It was an actual problem. And because this was a car wash and nowhere on there was water on this email. So I asked my client, who was the buyer, I was like, I don't know how accurate this is. They didn't even have water, and it's a car wash. And, their utilities was, it was $100. I was like, there's no way that it counts for water. So, and then it kind of rang the bell as to what else is not being done right, what else is not being accounted for. So that's one thing you want to look out for. Employee records, especially if the employees are going to stay with the business, you want to make sure that, they're good employees, that there's no, what the standards are, if there's any contracts, liens, do the assets have any liens, is there any debt? Contracts, of course. The contracts is really important too, because it's going to tell you where the business is coming from. So if you have, if you have a lot of customer contracts or vendor contracts, that's also going to tell you how valuable that business is. Potential lawsuits is something that you want to ask about often. real property documents, obviously, like what's the land, is it leased, is it purchased, all of that. And then the intellectual property, if there's any trademarks. A lot of businesses think that because they're incorporated like with the Secretary of State, then that like automatically gives them a trademark or like a right to use the name. Something that you want to make sure that you don't have like 10 other businesses with the same name and there's no trademark and people might be confused. And then of course, and this is a very common mistake, is you want to make sure that the seller of the business has full authority to actually sell the business. There's so many times where I say, are you the only owner of the business? And then the seller will say yes. And then we look at their corporate documents and like, like the wife is on there and she owns half the company. And then they're like, oh, well, yeah, I mean, she owns half the company, but she's just there on paper. Doesn't matter. You still want to make sure that if someone's authority is needed, you want to make sure that they sign, because you never know, as far as the buyer is concerned, that they might come back and say, wait, I didn't authorize this. And then you find yourself in a lawsuit. And then, of course, any debts or financing documents that will speak to the health. And what I tell my clients, especially the buyers, is that the debts of the business, not only does it tell you about the finances of the business, but it tells you how the business is run overall. Because if the financial health is not being taken care of, then are the processes and procedures also not documented? Are the employees also not being taken care of? Because there's an expression, how you do, like one thing is how you do everything. So it's just kind of like the general care that they take for their business. In the guide that I have here, I have the whole checklist. It's not it could be longer, but I made it a little short. So it's like the last page is like the due diligence checklist that you could use. All right, so I just want to talk quickly about the difference between an asset sale and a stock sale. Does anyone, who knows the difference? Just raise your hand so that I'm not. If you don't, okay. So there's assets. So there's two ways you can buy the business. You can buy just the assets. So, like think about it here. There's chairs, there's tables, there's equipment, customer list, intellectual property. Like those are assets of the business. And then, or you can buy the company itself, meaning the shares, like the stocks of the business. And choosing whether you should buy the assets or the whole company is a legal decision. And it's also a financial decision because it can impact the taxes too. So, it's less liability for a buyer to only buy the assets, because if they buy the stock, they buy like the shares of the company, then like the history of the company and all the liability with the stocks is going to come with to the buyer. So like if there's a potential lawsuit by a company, for example, or like a third party vendor, if you only buy the assets, then you can avoid, like as the buyer, you don't have that liability because you're not buying the actual company. You are their own company, and that third party who's suing has no contract or no relationship with the buyer because they're just buying because it's a new entity. So that's just one example. However, buying stocks could still be a good way. So for example, like healthcare companies, usually you want to do a stock sale because of the history. Like you do actually want to keep the history of like the health insurance and the credentialing. If a lot of the business like revenue heavily relies on contracts and like these ongoing relationships, you want to make sure that those relationships actually transfer to the new buyer. But again, if you're not buying the actual business, then those contracts won't transfer automatically. So in that case, it might be better to actually buy the stock. So it's really case by case, but generally like smaller businesses, they usually just do an asset sale. It's easier, it's faster, it's more simple, and it's less liability. So I usually say like businesses under $1.5 million are usually automatically, assets sales. And then once you go more, it could, vary. And then let's see, what's it? Sorry. However, there is one exception. Now, I did say that when you buy the assets of the business, then you don't, like as the buyer, like the liability, it does not transfer to you because you're not buying the history. But there is an important exception, which is the liens and the tax history, particularly the the sales tax and employment taxes, because the government, because like Uncle Sam is always going to find a way to get his money. So if there are any outstanding taxes, they can attach the lien or that liability to the assets. So like to these chairs, to these tables. So even when you buy the assets, that could still transfer. And so it's important to do a lien search. And I'm going to talk about some other ways to protect yourself. And I see that this is so overlooked because the buyer says, well, I'm not buying the company. I don't have the liability. And they completely don't realize that, no, actually, like I said, Uncle Sam is always going to find a way to get his money. So that's that. All right. So, so once you do your due diligence and you choose how you want to buy the business, I'm just going to go over it. Assets versus stock versus asset purchase agreement. So, so what happens is when you get all of the response to your due diligence, you might find that the business has certain problems or there are new things that you discover, and using those question marks or like the good parts of what you find, you use that to build your purchase agreement. So for example, I'm going to use like a basic example, like if there is a restaurant and they have a lot of equipment, and the seller swears up and down that they took like good care of all the equipment and they have, like someone come every year and maintain everything, then they can put that like as a representation or part of a warranty. Same with contingency. So let's just say, for example, if someone or if a buyer is buying an orchard, right, and it's coming close to the season of that fruit, but there has been history of like droughts, well, you can put a contingency that the buyer will only buy the business if there's no drought this year, for example. And of course, there's like financing contingencies as well. Liability is the same, with financing. And then the buyer could find that the business has more liability than previously thought, and so they could actually like renegotiate the purchase price. And then a holdback clause. This is an underutilized tool, but basically, if the buyer is concerned about certain aspects of the health of the business, and the buyer won't know for sure if it's a problem for the buyer until, say, 6 months out, for example, then the buyer can actually withhold a certain part of the purchase price in an escrow account for a certain amount of time or until a certain event happens. And then the buyer can actually self-help themselves to that remedy instead of having to sue the seller for a breach. So it really puts more power into the buyer, especially if the seller is going to go retire on some beach or disappear. So it's like having that account or having that money is a security. Oh, okay. All right. So the exhibits. So we got the purchase agreement, but that's the contract. Now, what are the documents that actually transfers all of those assets to the buyer? You have the bill of sale, the assignment, like an assumption, which is basically like if there's any contracts that need to transfer. A transitional agreement to if the buyer wants the seller to stay on for a certain amount of time to help transition, you can work out those terms. And if there's a franchise involved, you want to make sure that you have the franchisor consents. Same with the landlord consents, because if you're buying a business, like you're buying all the relationships too. So if there's any party that also needs to consent, then you want them to, sign off so that the buyer isn't buying an empty bag, Corporate consents, which is like the seller's consents of everyone, a list of the assets, and then the purchase price breakdown. And that's where you want to have a good accountant to help you. So because, for example, like the business, it's going to have the assets, like goodwill, real estate, the customer service, you want to break that down. And then that can actually inform how the accountant, will do your taxes. And especially in an asset sale, you can do like a lot of tax write-offs because of the depreciation. So you want to make sure that you properly, assign that value. All right. So book sales notice, that's what I was talking about before, is one way that the buyer can protect themselves from overdue taxes that the seller has not paid. So again, it's going to be like the sales tax and the employment taxes. So after signing the contract, but before closing, one of the parties, usually the buyer, handles it because it's kind of their liability. You send a copy and you send a notice to like the Department of Revenue. And it has to be done at least 10 days before closing. And then they will do an investigation, and then they'll say, okay, there are certain taxes owed. And then they will actually, or like the Department of Revenue will put something called a hold, and then they'll tell you how much of the purchase price has to be withheld until the taxes are paid off. And then oftentimes it just might be that quarter that wasn't finished. So it doesn't mean that the seller has not been paying their taxes. It's just like, okay, like we're still in the middle of the quarter or something like that. And then so the parties will put like those funds in an escrow account until the Department of Revenue clears that. Cook County has its own requirement, and it's like 45 days notice, which I think is really long. But that's how the buyer can protect themselves from taxes, or like if there's a lien on the asset. So that way, like they get their assets free and clear, and it's confirmed by like Uncle Sam himself that there are no taxes owed.
Just 10 days of signing?
I'm sorry?
Just 10 days for this notice?
It has to be at least 10 days before.
Okay.
So I have several people come to my office, and they have done everything themselves, like the buyer, and they're like, okay, we signed the contract, we did everything, and we're going to close in 2 days. And I'm like, hey, buyer, you need time. And it's not up to me. They're like, why can't I close in 2 days? I was like, it's not about me. It's you want to make sure that you're buying these assets, and you want to buy them free and clear, and you won't know for sure. And the buyer might be honest with you, and they might not be. Or sometimes the seller might just forget. So this is like, that's really the best way to protect yourself too. So yeah, don't overlook that. So then step 5 is closing. And, like I already talked about these documents, but then so the purchase agreement has been signed before, but then at closing is where like all the other documents are signed, licenses to employment agreements if the employees are transferring over, and then the escrow account if there's going to be a holdback, and of course then the buyer pays the seller. And then that's step 5. And then post-closing success. So okay, now you bought your business, now what? You want to familiarize yourself with the standard operating procedures of a business. So what is the SOP? It's basically like just the manual of how the business is run, because a really good business basically can actually run without the owner. So meaning that every role, so for example, the assistant knows what they're supposed to do. They have an agenda, they have scripts, they have like you could actually just put like a random person in their place almost, so that they know what their role is, and so that the business owner is not constantly reinventing the wheel. And so if there isn't, then I would encourage the buyer to put them in place, because that would increase the value and the efficiency of the business. To examine extra costs that can be cut. So we have people like Neil that actually specialize in this. So I'm going to do a shameless plug, where if a business, especially because I think a lot of business owners get really comfortable with some of their expenses, and they don't realize that they're overspending on things without realizing it. And they're just so overwhelmed with running the business that they forget to, just look at those, those expenses. And so you can bring someone in, or, I guess you could sit down and do it yourself, but that's not the best use of your time. So bring someone in like Neil, who could do that for you. And then of course, interview the employees. This is really more of like a practical, you want to keep your employees, especially the ones that you kind of bargain for. And so what will make them happy, and do you want to transition them more seamlessly? And of course, try to work on to filling in potential gaps, from the seller, because you want to buy a business, but a lot of times people want to actually grow the business. Like they want to buy the business, but to keep it stagnant. And, if it's like you're either like growing or dying. So there isn't really like a real thing called stagnancy. So you want to make sure that the business is going to continue to run successfully to get the return on investment. Plus, if you're a buyer and you're financing the deal, you definitely want the business to be successful, because so that you can pay back the loan. All right. So thank you. So I'll take any questions. Yeah. Does anyone have any questions? Neil.
I have a couple questions.
Sure.
First question is on contracts.
Sure.
So when a business is being purchased, I would imagine some of the contracts are like a real bonus to get. So you're wanting to buy a business that has contracts with clients. Are there also contracts with vendors that survive the sale? So you've got a contract with a supplier.
Mm-hmm.
and does that survive the sale? And does that depend on whether it's an asset sale or a stock sale?
That's a great question. So it depends if it's an asset sale or a stock sale. Mostly what I've seen is that the vendors don't mind transferring, especially because that's going to be how they make their money. Sometimes, because like most vendor contracts, especially on smaller businesses, there's no time length. It's really, the contract is more about how that will actually like govern the relationship. So they don't mind just transferring over. But if there is so let's just say that there is like a year's worth left in that vendor contract to provide a certain supply, and the seller is basically checking out, then that liability or the buyer will want that liability to stay with the seller. But usually like they'll transfer it out because people don't mind. It's also a good practice if you have a contract. A lot of contracts automatically have a clause that will allow for the sale of the business. And so that's a good practice to have depending on the nature of the business. Did that answer your question?
Yeah, definitely.
Yeah. Okay. And then do you have any other questions? I thought you said you had a couple. Okay.
So in the process that you were going through, is there a point where the seller gets a pretty good, I know they do evaluation.
Right.
And so they know what they think it's going to be worth.
Mm-hmm.
But just like selling anything else, I'm guessing if not a lot of people are interested, or the offers that they get are not what they need to go sit on the beach and drink Mai Tais.
Right.
Is there a point where it's easy for them to kind of back out and go back to the drawing board, not back out, but go back to the drawing board and improve the business and then try again in a year or two? Or are they, by the time they get the offer, are they kind of locked into the letter of intent and everything?
So are you talking about like for the seller to back out or the buyer to back out?
Or the seller. If
Yeah.
they feel like they're not getting enough to do what they want if they feel like they're not getting enough out of the business, or it's not going to sell for what they want.
Well, once you're at the LOI stage, then the parties have agreed to a purchase price. Yeah, or at least a tentative one that they're comfortable with. But before then, I mean, it's really like the sale of the house. Like at the end of the day, a thing is only worth what people will pay for. I mean, you can do all the valuations you want. If no one wants to buy it, then don't buy it. So first and foremost, I tell my sellers, like, if you know you're going to sell your business, you should plan like 2 years in to make sure that you get things in order so that your business is actually marketable. Yeah, it would just sit on the market. So with the broker, sometimes they list those businesses for like a year plus, and the broker will try to talk some sense into the buyer or the seller to be like, either get things in order or lower the price. But yeah, did that answer your question?
Yeah, that's great.
Awesome.
Thank you so much.
Did anyone else have any questions? Yeah.
I always had a question about when you buy a business, like for example, in the healthcare field, in the nursing home world, I've been through several transitions where we were owned by one nursing home organization and then another one bought it.
Mm-hmm.
What about the outstanding receivables? Like we wait a lot of times, let's say on Medicaid to make
Right.
payments. So if they sell the business, do the new owners get all of those receivables that were due? Like sometimes you're waiting 12 months or 13 months for payment. So does that become the new owner's money, or does it go to the sellers?
That's a great question. So the question is about receivables and who is going to take over those receivables. So usually that's actually negotiated in the purchase agreement. And usually the sellers want to keep it, which is fair because it's there. So, but also one thing that's kind of on a similar note is like also deposits. So deposits are their money that provided, but for services that were not rendered. So the buyer doesn't want to take those on necessarily, or sorry, they do want to keep those because it's for services that have not been rendered. So they're going to need those resources to actually fulfill those obligations. But actual receivables, usually the seller is going to want to keep it, negotiate it.
And then what about agreements that they have with employees? If I buy a business and you've made agreements with employees, for example, I know the salary can't be changed, but sometimes they do like bonuses and
Right.
All different kind of 90-day bonus, 100-day bonuses. Do those things have to be paid, like in an escrow account, they have to give us the money for those things? Or is that something that the new owners would take on all of that financial debt?
So if there's an actual contract, with a seller, if it depends if it's going to be an asset or a stock sale. So if it's a stock sale, then then the business is going to continue to run as if there's no new buyer in terms of the company. So the contract will stay in place. All the liabilities are going to stay the same. If they're buying the assets, no, then the obligation of the current employer, the seller, it stays. Sometimes maybe the parties can negotiate something where the seller will provide some funds to cover those bonuses, especially if they just want to get away. And it's an incentive for the buyer to want to negotiate that to keep those employees. Because in an asset sale, because there's no contract with those employees, then those employees could leave. So those are just some ways that the buyer could try to keep those employees, and they can have discussion with the employees like, will you stay if I buy, kind of thing. So it really just depends on the actual transaction, if it's an asset or a stock sale, and the nature of those employment contracts. But those are all points that are negotiated during the purchase agreement phase. That answer your question?
Yep.
Yeah.
But at what point does the buyer then turn in earnest money? Before due diligence, after the LOI?
So it depends. So there's different escrow agreements. Okay, usually if there's a broker involved, which you're going to see, the broker usually will take a deposit in exchange for the LOI being signed. And it's usually like refundable, but just to show that the buyer is serious. And that will usually go with the brokers. I think they usually hold that money.
And how much of it?
I think they hold anywhere. I've seen like up to like 5 to 10%. Yeah. Or sometimes it's just a fixed amount, like $3,000 or $5,000. So that's one thing. And then like the actual holdback clause is usually after due diligence, because that's when you kind of see what needs to be held back. And then with the like bulk sales notice, it's usually days before closing or at closing is when they'll transfer the money. So like at the purchase price. So like, for example, if I'm the lawyer and I'm going to be holding the escrow funds, then like, and that's $100,000 purchase and I'm going to keep 20,000, like they'll send 20,000 to me and then 80 to the seller. And then I'll hold on to it until it gets released under like whatever terms spelled out in the escrow agreement. Yes.
Thank you for very informative, lecture. And I want to ask, in our culture, we trust so much. We don't do documentation.
Yeah.
And then we have a lot of problems.
Mm-hmm.
So if, the contract is done by the two parties, there's no lawyer involved, and they transfer the property and everything, and then the seller, the buyer refused to give the money to the seller. Is that agreement between the parties without, attorney or without any documentation, is it valid? You can take it to the court?
You can, but it's going to be very expensive and difficult. So there's a law, it's called the Statute of Frauds, which basically requires certain contracts be in writing. And one of those contracts is anything over $500 or the sale of goods for more than $500, except between merchants. So
they will be held accountable for that?
They can be, but sometimes it's just hard to prove. It just becomes a battle of he said, she said, because then sometimes there's reasons why the buyer doesn't pay. They might say, well, I didn't get what you promised, so I shouldn't have to pay you. It's just really expensive and a complete headache and a situation that you don't want to be in. So you can, but it's a nightmare to be in. Just to be clear, like you don't need lawyers to do this for you. It's just that you want to have lawyers because they've done this before. Like it's kind of like I'm not gonna build my own house because I've never done it before. I won't even make my own steak. I'll go to a restaurant because I'm not good at even making steaks, because you just need a certain kind of oven. You need, it just needs to be done a certain way, and I can't trouble myself with that. So so the short answer to your question is you can, and what will happen is it really depends on the specific facts of why the buyer is not paying. And it can be very expensive and a complete nightmare. And I mean, a lawsuit, especially something like this, it's probably going to cost at least $30,000, $40,000, or $50,000. So if you're talking about a smaller transaction, it's like, that could exceed the purchase price. And then that's if you win, so then, yeah, I would not. That's why I do this. Remember I talked about at the beginning? Yeah, I talked at the beginning because I used to see that a lot.
I always say
Yeah.
the attorneys in the beginning, not at the end.
Yes, exactly. I say that like some people, they sign the LOI and then they come to the lawyers. on a good day. And even then I tell before you sign the LOI, because I've seen a lot of mistakes in LOIs, or like I said, there are certain discussions that you have, like the deal breakers, like sometimes people don't even do that. They just sign some template. And I say, oh, wait a minute, we got to start a little bit. And so, and it can hurt the transaction, because at first the parties might agree to something and then you backtrack and it just kind of kills the trust. So when to hire a lawyer would be, at least talk to them and see when should I hire you? And then, and here's my situation. So when people come to me and say, we're not even sure if it's a profitable business, I say, okay, decide if you want to buy the business, do the numbers first, and then come back to me. But if they're already like in that process, then I would say, yeah, definitely hire the lawyer. So earlier.
The lawyer's not going to tell you this is a good business to buy, because you said that you tell them to look at the numbers. So the lawyer won't tell you this is a good business to buy or this is not. You will push that to the accountant.
Yes and no. To do that analysis, sometimes like it can be very complicated, and lawyers are not accountants. They're not numbers people. But like in smaller transactions, it was very clear to me. Like in one instance, I was like, well, I asked my client, like, where's your profit margin? Like, you're telling me that they make this, and then here are the expenses. Where's the profit margin? And so like when I see it, I bring it to their attention. But by the end of the day, I tell my clients, like, I can only give you information and tell you what the risks are, but it's their decision in the end. Like I wouldn't tell someone I wouldn't buy this business, or don't do this or don't do that. I say, here's what the issue is. It's your choice. Did that answer your question? Yeah.
What somebody's willing to pay, like you said before.
What do you mean?
The business is worth what someone is willing to pay.
Exactly. Yeah. So. Any more questions?
Yes.
Go ahead.
Let's say we sign a contract, everything goes well,
Mm-hmm.
and the seller drops the contract
And the seller choose not to.
to sell after signing a contract.
Can you give me maybe a little bit more details about what you're getting at, so I can best answer the question?
Like a real estate,
Right.
like a commercial,
Yeah.
and like the title company, let's say, like a meter is missing, like the water meter in the city of Chicago, there is no meter. So
Right.
we order a meter, but take long, like 6 months or maybe
Right.
more. So now, like the seller, he trying to drop off the contract. Can he do that? Or-
So if there's no good reason, then no, they can't. I mean, it would, like you said, it's a breach. But in that specific case, a good contract would have that taken in. Like you'd put that as a contingency and put that in the timeline. So, and say, for example, if the water meter is not installed by X date, then the seller can drop out and it's not a breach anymore. So that's why it's important to have those discussions and do your due diligence. Then the buyer knows, like the buyer knows the risks of entering into the contract and what it needs to do to make sure that the deal goes through, and maybe find another remedy. And then the seller won't be in a situation where like they're being sued for breach because they put that contingency.
Like an escrow hold or something.
Yeah, or even just a straight up contingency. Like the seller does not have to sell if there's no water meter installed by a certain time. And that way it's not a breach. So that's why I asked more details. Like why would a seller want to back out anyway? Like no one just says, I don't want to sell my business anymore. I mean, there's a reason. So having those discussions is important to avoid that conflict and to also just manage expectations. Did that answer your question? But if there's no good reason, they just don't want to sell it, or they're getting a higher price from somebody else.
Yeah, maybe this is what happened.
Yeah, then in that case, no. I mean, once the purchase agreement has been signed, or if there's a violation of the no shop clause too, remember I talked about that too, then that would be considered a breach. And then the buyer could go and enforce the contract.
Thank you.
You're welcome. Any other questions?
That would be like an unforeseen, right? Like if he didn't really know, he had to put that meter in.
Yeah, he didn't know that the meter was stolen or missing. So when
Could have put something in the contract like unforeseen.
when we ordered the title,
Like something
last week,
unforeseen.
Oh, that's a property, I see, yeah.
When the title company ordered the water bill, they find out there is no meter for a long time.
So that also depends if they put, so that's where like the warranties come in, and the representations come in, or what's the other one I'm thinking of? Or if it's as is, like if they said it was as is, then no, the seller doesn't have good reason, or the buyer doesn't, no. You can't, the seller doesn't have a good reason to back up. Or no, the seller would want to enforce it in that case. But it depends on what you negotiate and having so that's why it's really important to have a good lawyer, so that so you don't end up in those situations. I mean, you can't foresee everything. Yeah, unfortunately, there's some things happen, but usually what people have, like some experience, if you have a good attorney, they should be able to, at the very least, manage the expectations of the parties, because even if there is some kind of breach, if there's still some goodwill, people don't want to sue. They'll try to want to work it out. Otherwise, but once you kind of because I find people go to court, it's not always just about the money. It's sometimes about or it's about their ego and their feelings are hurt or something like that. Like, it sounds petty and childish, but that's true. That's real. People want to go on the principle. But so if you keep some of that goodwill because you had a good, honest, open communication, then people might just try to work it out outside of court.
There's probably like 100 different contracts. Is there one contract in particular that, or they apply better to certain businesses, or is there like one contract that's like a starting point after the LOI?
Yeah, I mean, I guess, but I mean, you tailor it really to, I mean, so are you asking about like templates?
But like, one would not have to worry about that. That would be the attorney, which contract would be best for the situation.
Yeah. I mean, do we use templates? Yeah. I mean, but we start with, it's like a tool. A template is a tool. It's like a shovel, right? The shovel can only be as good as the person using the shovel. So, I'm not going to reinvent the wheel and type everything from scratch every time. But usually, as a lawyer or like any other professional, you don't start from scratch every single time, but what to, so like a lawyer using a template is not the same thing as just a random person using a template, someone who doesn't have that background, because they don't know what they don't know. They'll change things, include things, not include things that should be in there or shouldn't be. And then sometimes people think, we'll just throw in everything just to be safe. And so, even some lawyers do that. And no, you don't want that either. Yeah, because that's not always because.
Like, how long is it? Is too long, or?
It's not about the length. I mean, I don't really worry about the length. If it's a smaller transaction, I worry more about the length, not because of the length itself, but because I don't want to intimidate the other side too much. And then there's some things that just don't need to be in there.
Like, the more expensive the business, does the contract get thicker?
It's not always like that.
50, 100, 200,
Yeah.
$500,000?
I mean, it's more about liability than expense, I would say. So that it's more about like the risk versus the actual size of the business.
Or the size of the contract, I mean.
Right. It's not related to the size of the business. It's really, if there's anything that gets thicker, it's the due diligence, because then they're doing a lot more. Like if it's a bigger business, it has more contracts. There's more history. There's more financial documents to look at. So honestly, it just depends. I mean, I had a matter recently where it ended up like the legal fees ended up being more expensive, not because the business was small or big or even complicated, but just because managing the parties' emotions was difficult. Like, people were flaky, following up. The other lawyer was like hard to get a hold of. They weren't doing everything they were supposed to do, so we had to pick up the slack. And so sometimes it's just about the people involved. And then once the people get complicated, then the parties, will want to put more things in the contract because they want to protect themselves more, because you start to lose that trust and that goodwill.
I don't advise with those standard contracts.
Yeah.
We always advise our students at the university that each case has its own specialty.
Yeah.
So no matter how small the case, the contract, don't just get any contract, and because they use standard contracts for buying and selling, for renting, for this, I prefer that, to go and to have, special terms for each case or for each contract.
Yeah. And it's not really about I always tell people, it's not always about the words on the paper. It's the transaction as a whole. So it's behaviors is what you should do. It's what you should say. And, so it's about getting to your goal. It's not about, so the contract at the end of it, it's just a tool. It's a means. Like, some people think the contract is the end. Like, I just want a contract. I'm like, well, is the contract going to get you to where you want to go? If you're the seller, is this contract going to get you to like retire on the beach and drink, like strawberry daiquiris every day, so that's the end goal. If the contract doesn't get you there, then it's a useless contract. A cheap, bad contract is more expensive than an expensive, good contract. So, yeah. Well, this was great. Any other
Thank you very
questions?
much.
You're welcome.
Thank Thank you so much.
I am offering, if you book now, I am offering complimentary consultations. Usually I charge for my consultations, but if you book now, you can scan the QR code and you can book something now too. And if you're looking, it doesn't look like anybody here is trying to buy a business, but if you were, it would be a good opportunity to chat with me before choosing. Yeah, not for now.
Hopefully we selling one soon.
Oh, okay. Well, that'd be great. Well, I think I'm doing another one on how to sell a business. So we'll talk about the other side. Well, thank you everyone for your time.